Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard.
Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, March 27th. So please ask for the time that you need to get out the salient points of your arguments. Please understand that we are fully familiar with your briefs. We're fully familiar with your arguments as well. The red light is for you, not for us. If the members of the panel have additional questions, they will certainly put them to you even after the red light has gone off. People v. Jeffrey Ashley. That matter is submitted. Matter of S. Hazara. That matter is submitted. Grippo versus 95th and 3rd. 5-2, 5 and 2 and 5. Elon versus Ali. I'm sorry? And how much time are you requesting? 6 minutes. And did you want any time in rebuttal? Okay, fine. So there's no respondent, so that's a submission for the respondent, and for you, we'll give you 3. People v. Michael Berger, I'm notified that the attorney for the appellant is submitting. Is there a respondent? That matter is submitted. Munoz versus the City of New York. How much time are you requesting? 5 minutes. 5 and 2 and 5. Fox and Maine versus Pyramid. 6-2-6. People v. Khan. 5-2-5. Vogel v. Lorne. That matter is submitted. 373-381 Pass Associates versus Moss. Who else? Five and two. 5 and 2, 2 and 2. Apologies. People v. Aaron Smith. 5-2-5. People v. Victor Corral. That matter is submitted. Corley versus 337 West 138th Street. That matter is submitted. First case for argument is Grippo versus 95 and 3rd Avenue.
Good afternoon, Your Honors. May it please the Court, Michael Zhu, Appellate Counsel to Morgan Levine Dolan, attorneys for the plaintiff appellant. The lower court's order should be modified and the dismissal of the 240 claim vacated, plaintiff's motion granted. The facts of the matter are really not in dispute. He's standing on an 18-inch high inverted bucket, lifting a 130-pound slab of marble with a coworker. And as he's doing that, as the bucket is wobbling, he's straining to hold the slab of marble while keeping his balance, and he tears his bicep muscle.
Counsel, does it matter that A, he didn't fall off the bucket, and or B, the slab did not fall on the plaintiff to constitute a falling object?
No, neither. Neither factor requires either a dismissal or a denial of the plaintiff's motion here. His testimony is that because he's standing on an inverted bucket that wobbles, that exposes him to an elevation-related danger. Just because he doesn't fall doesn't mean that he's not protected by the labor law. A more stable...
What precisely caused his injury?
His testimony at page 150 of the record is he's standing on the bucket is wobbly, it's hard to balance, and it's quote-unquote crazy. So as he's lifting it, he's trying to maintain his balance, and he and his coworker lifts it up 2 feet up, and that's when he feels a strain in his arm. He doesn't, I'll grant you, he's not saying, oh, and I almost fell off the bucket and I'm trying to hold on to it. He doesn't say any of that. But what he does say is the bucket is wobbly, it's hard to maintain a balance, and I strained while I was lifting it. So,
Does the height of the bucket from the ground make a difference?
None.
This bucket is but 15 inches. Is that dispositive in any way?
none at all, because it's not his fear of falling 15 or 30 feet or 5 inches. It's his inability to maintain his balance as he's trying to lift. So it doesn't matter how tall or how high up the bucket is.
Well, the question as to how tall the bucket is or how high up it is in terms of 15 inches tall is whether or not that is sufficient or sufficient elevation.
But the issue is not whether it's the height, the issue is whether it's a stable platform. So if he's not provided a stable platform and he's not able to maintain his balance, and that causes him to strain, because he does testify that he's in an awkward
What if he
position.
was standing on the ground and he's strained as he's trying to put this piece of marble on the wall?
I'm not here then. If he's standing on flat ground, if he's performing a deadlift in the gym on a floor with a coworker using a suction cup, there are cases that do hold that you need hoisting devices, but this isn't just one of those cases.
So elevation, so it is relevant. I mean, as my colleague's point and your response, there is some relevance to the fact that it is a bucket which is in fact elevated off the ground.
Correct, but the fact that it's 15 inches doesn't mean that I lose, or doesn't mean that
But
that
there
my
is
case gets
elevation,
dismissed.
so your argument is that there's some elevation, and so that's sufficient.
Yes, I mean, look, there are cases that I cited in my brief where a
Okay.
worker is standing on the second rung of a ladder, and at that point, that's when he falls. Now, granted, he falls there,
Counsel,
but my
I'm
client
sorry to
doesn't fall.
interrupt you. You believe that Grippo met his burden on his summary judgment motion?
Absolutely. He established that there were safe, that the bucket and the suction cup were inadequate safety devices to allow him to perform work at an elevation. And he's performing work at an elevation because the two workers needed to be high enough to be able to lift the slab of marble onto a bathroom wall. So other devices were either not available or just couldn't be used in that bathroom.
Did anyone tell them about the wood bench?
There was no testimony as to whether Mr. Grippo knew about the availability or that he was told to use it, and for no good reason, he chose to disregard that.
And the I'm sorry, I forgot the name, the baker's scaffold, was there any discussion about that, whether that could fit into the bathroom
It
or?
would not have fit. It would not have fit. But
The bench would have?
I'm sorry.
The bench would have fit?
I don't know if there was any testimony as to whether the bench would have fit,
I
but
thought the testimony was from the foreperson as well as from one of the coworkers that the wooden bench was what was normally used under these circumstances.
yes, but he certainly wasn't told that he had to use it, and so meaning there are no issues as to whether he was recalcitrant or not.
Right, thank you.
Thank you.
Good afternoon, Your Honors. Patrick McAvady of Lewis Brisbois for the respondents, and may it please the court. There are two criteria here that have to be met in order for 241 to apply. The first requires a physically significant elevation differential.
Well, you know, this court has previously held that an inverted bucket is not an adequate safety device. You're aware of that?
Yes, Your Honor.
And you're not, and you're also aware that in one of the cases, I think it's the Portillo case, the bucket there was 18 inches. So, I mean, we're talking about 3 inches, so it's really negligible. Is that really critical here? It's really the notion that he's off the ground and in a situation where he wasn't stable enough to be able to do the job he was supposed to do.
Your Honor, I think there's 2 points there. First, the difference between the 15 inches and the 18 inches I don't think is negligible because, and this was 15 inches, and there are cases that this court has held, and we cite them in our brief, where a height differential up to and including 18 inches has been found not to be physically significant. So the 15 inches here, we believe, falls within that line of cases that hold that the analysis could and should end there because 15 inches is simply not physically significant. Now, as to the bucket and whether or not it was an adequate safety device, we believe that the existence of and the use before of those wooden benches is relevant. And we would concede that the testimony might not be enough to fully make out a recalcitrant worker defense because that is
You
a,
concede that the bucket, an inverted bucket, is not an adequate safety device?
based on this testimony, if he's saying it's wobbly, then perhaps, Your Honor,
Oh,
but
no, not only based upon his testimony in terms of it being wobbly, but also given the task at hand. I mean, what's the weight of these,
Marbles.
the marble? I mean,
believe
we're
it was
talking about
130
marble
pounds.
stones. The device is about 150 pounds, right?
I believe it was 130 pounds between two people.
Excuse me, 130 pounds between two people that they're lifting, and I don't understand the argument that lifting 130 pounds with two people, lifting marble 130 pounds, that an inverted bucket would be a sufficient safety device.
And Your Honor, the reason we bring up the wooden benches,
I don't understand how the wooden benches would be a sufficient safety device either.
well, there's testimony from the foreman and his coworker that those benches are secure and they've been used sufficiently in the past. And even plaintiff himself in his testimony below said that those benches were secure, and if he had been provided them, this wouldn't have happened. He said that in his testimony.
Right, but he was not provided them, nor apparently was he ever told about them, right?
Well, Your Honor, that's not what the testimony necessarily says. Whether or not he was told to use them and just simply refused not to, there's no testimony of that, so we can't necessarily make out recalcitrant worker. But there is testimony that those benches did exist on the site. He had previously used them in the past.
Do we have an expert who says at any point in time that an inverted bucket is safe? And mind you, there's all kinds of buckets, hard plastic, rubbery plastic, so on and so forth. I don't know if the dimensions are ever described other than the 15 inches.
Correct.
That's one question. But then the other is, does anybody testify anywhere as to the adequacy or potential adequacy of the wooden benches other than the foreman and so on? Do we have an expert? Do we even know the dimensions of the wooden bench?
No, Your Honor, there's no testimony from an
So
expert.
we're supposed to speculate that a wooden bench would be safe?
The testimony that we do have is from the foreperson who, in this case, would sort of know the.
Sort of, but do we have a description as to the dimensions of the wooden bench? I mean, we're talking about lifting a marble slab that's 4 foot by 3 foot by 1 inch at 130 pounds, which kind of calls out for some type of safety device to be employed.
And to that point, Your Honor, I do want to just briefly stress that the suction cups that were used, there is no testimony that those suction cups failed in any sense of the word. Those were provided to hoist them. The argument here is that the bucket wobbled and maybe that made him brace himself, but the suction cups themselves, there is no testimony that those failed.
You do see the visual that comes to my mind anyway of someone teetering on a bucket, holding up 130 pounds, trying to stick it to the ceiling with a suction cup, right?
I do want to stress with this again, and this goes back to my original point, which I think should be and could be the end of this analysis. It was 15 inches. That is basically a step up. If he is wobbling, and that's why cases that are cited to by plaintiff involve these tall ladders, these high scaffolds, where the height is very essential to what's going on. This was essentially one step up, and if there is a wobble, if there is sort of
I mean,
movement,
there could be injury just from lifting the 150 pounds.
and yes, Your Honor, I believe pulling a muscle while lifting a heavy object is an ordinary danger that you could expect at a construction site. It is not the special hazard that's envisioned by 241.
Thank you.
Thank you.
As to that last point and to Judge Justice Friedman's comment there, I point to this court's attention a Second Department case, Vislaki. In that case, plaintiff standing on a concrete pedestal. There's a vertical rebar sticking out of the concrete pedestal. He wraps his leg around that rebar, holding onto a 70-pound jackhammer, and he's jackhammering. And he needs his leg to hold onto the rebar because he doesn't want to fall off the pedestal. As he's jackhammering, he wrenches his back and he rips his stomach muscle. He doesn't fall, nothing falls on him. Second Department holds, 240 applies. So as to Justice Friedman's point before,
Counsel, the plaintiff here injured himself while trying to avoid from falling, correct?
correct, yes.
While
While he was performing a work from
carrying
an elevation.
Thank you.
Yes, exactly.
And I'm looking at, what is this? Ravelli?
sorry.
2011 case, I can't really figure out how to say this, Reavely, which says that the fact that the plaintiff did not actually fall is irrelevant as long as the harm flowed from the application of the force to that person.
Yes.
Could you address that?
Sure. The force to the person is him trying to keep his balance on this wobbly bucket. He's got one hand on the suction cup, one hand on the wall. That's his testimony. And he's doing this. So the force of gravity is him trying to keep himself alight on a bucket that's moving while holding on to a slab that he doesn't want to fall and while trying to stable himself against a wall.
And none of our cases have ever stated that you actually have to fall, that there has to
Correct.
be an actual fall.
Correct.
Thank you. Thank you both. Elizon Master Participation Trust, or Elizon. Yes, you may proceed.
Good afternoon, Your Honors, and may it please the Court. Matthew Walters for Appellant Shehabano Ali. Today's argument involves two motions, so first I'd like to discuss the reasons why the motion to substitute Shehabano Ali in place of her deceased mother should have been denied and the cross motion to dismiss granted. First, it was procedurally improper for plaintiff to use CPLR 1021 to substitute Shehabano Ali in this case. CPLR 1021 is just the procedural mechanism to allow.
Well, one of the questions is whether there was active participation in the litigation. So she came in on two occasions, and on one occasion she came in and she stated that her mother had passed. And then there was also based upon that, I guess, or based upon other conversations, there was a motion to withdraw. Is that correct? I mean, they moved to withdraw as to.
I believe the motion to withdraw may have been on the decedent mother's counsel's behalf. That
Yes.
was not a motion to withdraw by
No.
Ms. Ali.
I thought well, anyhow, the issue was whether there was, in fact, active participation in the litigation by your client.
Absolutely, Your Honor, and the answer to that question is a resounding no. My client merely appeared pro se one time to inform the court that her mother had died.
And then she
Didn't
moved,
she oppose the plaintiff's summary judgment motion?
right, and she
That
moved,
was
she moved for an order to show cause to strike, she moved for an order to show cause, and she moved for opposition of the motion for summary judgment.
Well, the motion for
She
some.
appeared at two conferences.
She attended one conference, and, Your Honor, I attended one of the conferences to remind.
According to this, she appeared at two. First one was September 16, 2021, and then November 18, 2021.
The November 18th was my appearance. It wasn't pro se at that point, Your Honor. But the answer to that is the appearance in November was strictly to remind the court that the case should have been stayed pursuant to CPLR 1015. And the original appearance pro se in September by Ms. Ali was to remind the court that her mother had died. She was not a party to the case at that time.
November 18th, did you file a notice of appearance?
No, I didn't, Your Honor. In fact, when I appeared during November 18th, I emphasized to the court that we were not submitting to the jurisdiction of the court, and we were there as a non-party strictly to remind the court that the case should have been stayed and that no conference should take place.
So on the November 18th, 2021 court appearance, it was noted that she was pro se because you had not filed a notice.
I'm sorry, I misunderstood.
So on the November 18, 2021 conference, it was noted that she was pro se because you had not filed a notice.
That is correct, Your Honor.
Right, so the point was she appeared on two dates.
If that's the way it should be characterized, then absolutely, Your Honor. But the
Counsel,
point,
can you address whether the plaintiff's motion should have been granted and treated as a successive summary judgment motion?
absolutely, I can, Your Honor. In order to put forth a successive summary judgment motion, this court has repeatedly held that there has to be some type of either new evidence or reasonable justification for making a successive motion.
And Younger's affidavit was in new evidence, correct?
No, because Mr. Younger was in the control of the plaintiff for the entire time. So they could have submitted the affidavit during the original motion, and in fact, they've never explained why that affidavit was not submitted on the original motion in the first instance, not in their appellate papers and not before the lower court, which is why we vehemently argued that the motion to renew should have been denied because there's a statutory requirement pursuant to CPLR 2221 that they provide some type of reasonable justification for not submitting Mr. Younger's affidavit during the original motion.
Thank you. Thank you very much.
Thank you, Your Honors.
Munoz versus the City of New York. Yes, proceed.
Good morning, Your Honors. Konstantin Pavlos of the law firm of...
Unfortunately, it's afternoon. But whatever.
Well, good afternoon, then.
I think the Yankee game started already. Yes, go ahead.
So, although the trial court properly determined that summary judgment on the issue of liability was appropriate, it erred in declining to dismiss affirmative defenses of comparative fault, culpable conduct, as well as irrelevant and ancillary defenses of assumption of risk, emergency doctrine, and qualified.
Is there anything in the record to support any of the, well, first of all, there was nothing put in by your adversaries as to your motion. Is that
That's
correct?
correct. Only an attorney affirmation.
Only the attorney affirmation. So there's nothing in the record to support those affirmative defenses. Is that correct?
That's correct.
Well, the assumption of risk, is that applicable to riding a scooter in a motor vehicle type accident?
No, it's not at all applicable.
So most of the cases dealing with assumption of risk in the personal injury context. And in fact, I think we decided a case where we stated that it did not apply in a vehicular traffic.
No, that's correct. When someone's lawfully operating a vehicle on a roadway, they're not assuming any risk. And even if they're violating the law in some way, shape, or form, such as crossing outside of an intersection, they're still not assuming a risk according to this court.
And was there anything in the record that this van was some type of an emergency vehicle or anything of that nature?
Nothing at all. And once the court, the underlying court, determined that summary judgment was appropriate, the burden then shifted to the defendants to bring forth some evidence that it was responding to an emergency. This was an unmarked sheriff's vehicle. It was not a fire truck or even a police cruiser. And the police report, the certified police report, said nothing about any emergency response, and neither did any opposition.
So your friends say that there should be additional discovery because this is somewhat premature and that there's discovery is necessary, I guess.
Well, no, because all the relevant facts were in the possession of the defendant driver, and this court, as well as the other appellate departments, have held time and time again in a motor vehicle accident, when the driver is in full possession of the facts, there's no need for, and in this case doesn't even mention what facts might be necessary to make a determination as to these issues, then there is no need for further discovery and a motion is not premature.
Because they have the ability to speak to Baptiste, who was the driver of the
Yes,
van.
Baptiste was there. He caused the collision. He knows exactly what happened.
I was very curious watching the video clip that purported to demonstrate the timing of the traffic light. From what I saw, the traffic light never went to green. It only had the yellow flasher and then the red light. And the photographs as well show that it's a left turn. The flashing light is for the turning lane exclusively. Is there any testimony that at any point that the car had a green light?
I believe the 50H testimony was that the light changed from green to yellow, and let me confirm that.
For the turning lane?
In the turning lane, but what the plaintiff testified to it as 50H was that as he entered the intersection, he observed that the turning lane light was flashing yellow, and therefore the vehicle immediately to his right should have yielded to him, who had a solid green light in the bicycle light in his direction of travel in the bike lane.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Elizabeth Friedman, and I am appearing for the respondents herein. Your Honor, Supreme Court correctly denied summary judgment as to the affirmative defenses here. The Court pointed out—
What issues of fact did the defendant raise as to the emergency doctrine or the governmental immunity?
Well, our position on that basically is that it's all premature without the opportunity to conduct discovery. So there were a number of affirmative defenses
What
that were raised.
discovery?
I'm sorry.
I'm sorry, what discovery?
Discovery, basically the deposition of the driver and
That's
other
your-
exchange of documents.
The driver is your client. The driver is your client.
Yes, Your Honor.
Okay, so you could not obtain a statement from your driver, from your client, an affidavit from your client in order to defeat their motion or respond to their motion?
Well, Your Honor, I'm not sure exactly what happened in the lower court, and or at what the proceedings and what the
Now,
decision.
you said that you needed discovery, so I'm trying to figure out exactly what discovery you're talking about.
Well, premature is to exchange of whatever documents, perhaps other witnesses. We don't know that.
Plaintiff
So
moves.
if Baptiste had an emergency, you can get an affidavit from him saying what that emergency was.
And you're correct, Your Honor. To my knowledge, that was not done. But I'd like to.
But what discovery would you need to get that done?
Well, I think that there could be further discovery even from the plaintiff because it was just a 50H hearing, and I believe that the plaintiff could testify at a deposition, and certainly there may be more facts
It
that
was
could be
more than
fleshed
the
out at that
50H
point.
testimony. He submitted his affidavit.
He submitted an affidavit, but even the plaintiff's own submission, even his evidence, did not eliminate all factual issues here
Counsel,
in terms
the-
of comparative
So,
negligence.
counsel, this is a motion, plaintiff moved for summary judgment. So what I'm not understanding is, yes, you're stating it's premature, but don't you still have an obligation to rebut that?
Yes, Your Honor, and in
And
fact,
how
we
did you do that? Did you
Well,
put
plaintiff had
anything
the
in?
burden on summary judgment. I'm sorry, I didn't
Go
mean to
ahead.
interrupt.
What did you do?
Plaintiff had the burden on summary judgment to show that there were no triable factual issues. And then the city did come forward and show that, in fact, the plaintiff did not eliminate all triable factual issues.
Counsel,
How did
looking-
you do that?
Looking at the accident report
Yes, Your Honor.
filed by the police, it simply says that the driver further adds that he checked his driver's side mirror and did not see anyone in the bike lane. That doesn't sound like there was an emergency. So it looks like emergency doctrine goes out with the dishes. Assumption of risk, I'm very curious as to whether there's any case law or any statute that says that driving an e-scooter
An e-scooter, right, not another motor vehicle. But an
means that you assume the risk, like you would if you were ice skating or horseback riding or parachuting.
Well, not only, go ahead.
We don't, I'm not aware of anything, anywhere that comes close. Governmental immunity is another one. That one goes out with the spoons and the forks. And
We're left with the knives.
now we're left with the knives, culpable conduct.
Culpable conduct.
There's no indication that there was any culpable conduct.
Well, Your
here.
Honor,
Well, I just wanted to add to that again, as I stated, Diaz versus Klausner, we specifically stated in 2021, we specifically stated that the defense of assumption of risk does not apply to cases involving traffic accidents. So, I mean, it's clear. So assumption of risk is out. Emergency, there's nothing in the record to show that there was any type of an emergency, that, you know, that Baptiste swerved into the bike lane or anything like that. It was trying to avoid another vehicle or another individual. So again, I don't see how you make out the emergency doctrine. Governmental immunity, how is, there's nothing showing that he was, you know, going to some type of an emergency, you know, flashing lights, et cetera. I just don't see that there's anything in the record. And I still come back to your argument in terms of discovery. I'm trying to figure out what additional discovery there would be in possession of the plaintiff.
well, in terms of, we don't know, in terms of the emergency
So what's
doctrine,
the
we don't.
issue of fact that you suggest there is?
I'm sorry, say-
What is the issue of fact that you're suggesting there is?
whether or not there was comparative negligence here and whether or not there were further actions
Well,
that
what
the
is,
plaintiff
what,
could have
what,
taken
what
to avoid
shows,
the accident.
what shows that there was comparative negligence?
Well, basically, he testified, and we have this in the record, he testified that he noticed the black van, stopped at the red light while he was in the bicycle lane. He saw that about 30 meters away, and then he was stopped at the red light, and then he proceeded through what he testified was his green light, but he was accelerating at this point to a speed of about 12 to 15 miles per hour, and that he didn't have time to apply his brakes. I think that raises an
Counsel,
issue
what
of
does
fact
that
as to
have
whether
to
he
do with
took.
the price of rice? He's
I'm so hungry now. You keep
What
talking
is
about the
happening?
Well, I
schools
think
and
that
the
there's issues as to
plates.
whether he could have taken evasive measures to avoid this
No,
accident.
I'm not,
And I
again,
think-
you know, he's on a scooter, he's in the bike lane. The driver, obviously, he's operating the motor vehicle and he's making a left turn onto 30th. I'm not understanding how there could be any comparative negligence on the part of the plaintiff who's on the scooter.
Well, Your Honor, I think that's an issue of fact that really could be fleshed out more.
And what did you,
And I think that he didn't, as the court pointed out, the plaintiff did not.
Maybe if we had
did
an
not establish
affidavit,
estab-
Baptiste, it would be an issue of fact, but there's nothing.
There's nothing, but I don't think the plaintiff's submissions showed the absence of triable factual issues here. And I think that's what the court pointed out. It said that the perfunctory cursory arguments by plaintiff do not even meet the standard.
perhaps as to the comparative negligence, perhaps, arguably. But again, as to the affirmative defenses, I don't see how you make out any.
Comparative negligence is certainly a damages defense, as the Court of Appeals in Rodriguez has stated. And in fact, that's an affirmative defense. That should be await trial. And the other affirmative defenses, our position was, it's premature at this point. They should await trial and more discovery as well. No reason at this early stage of the litigation to dismiss the affirmative defenses, and we cite many cases in our brief, both this court, from this court, and the Second Department, that have declined not only declined to dismiss not only comparative negligence affirmative defense, but other affirmative defenses as well. And we feel those cases should be followed here as well, and the court's order should be affirmed. Thank you, Your Honor.
Anything further?
Yes, just briefly, with respect to the issue of comparative negligence, it's not a perfunctory issue of fact, it's an issue of law. The plaintiff who has a green traffic signal in his direction of travel, as a matter of law, in the cases Harrington v. Sow is cited in our appellate brief, had no legal duty to watch for or avoid a driver who might fail to abide by another traffic signal, which in this case, the defendant driver did. He failed to abide by the yellow signal. So there is no duty to the plaintiff. It's not even an issue of fact whether he could have avoided the collision or
Right, well,
not.
that was the other issue your friend mentioned, whether or not the plaintiff took any or could have taken any evasive action.
I'm sorry?
Whether your client could have taken any evasive action.
Well, it's not a relevant issue whether he could or he couldn't, because he did not have to anticipate that the other vehicle would disregard the light.
And cut him off.
Correct. And with respect to whether comparative fault is a damages defense, I do not at all believe that that's what the Rodriguez case holds. Comparative fault is an issue on liability. It's related to liability. That's the court in Rodriguez said is a separate issue from liability, but certainly a separate issue from damages. The cases they cited on this point state merely once an apportionment of liability is decided in a liability phase of an action, then the jury can then determine damages as there would be a set-off depending on comparative fault. That's it.
Thank you both.
Thank you.
Fox and Main v. Pyramid. Yes, go
Good
ahead.
afternoon, Your Honors. Ken Labate from Mount Cotton, Woven, and Greengrass for the appellants. This appeal is from a partial denial of a preemptive motion to dismiss. The action itself arises out of the assignment of certain hotel management agreements from the respondents to certain entities that were created by my clients to manage those hotels. There's a threshold issue presented by
Well, my understanding is that the motion court, and in reading the transcript, you seem to be principally focused that their whole complaint is shoehorned into 11.1. That it's a performance-based metric that governs everything, and therefore, because there's a unique provision in the HMA for arbitration by an expert to determine the different values as to how the profit was working, the GOP, if I got that right, then therefore we don't belong here in court. That's basically your position.
that was one of our arguments. We believe that the HMAs are clear, that my client was given 2 years to manage these hotels. without
But
interference.
that's only if it's an Article 11 termination.
Well,
Isn't there a separate Article 12 termination? And isn't it the respondent's point that they're proceeding pursuant to Article 12?
that is their point, and there is a separate event of default provided for in Article 12. Article 12 is silent as to a performance-based.
So what's the flaw in their argument?
The flaw in their argument is that they are squeezing into 12C, or trying to squeeze into 12C, which is a catch-all phrase, a catch-all category, all performance-based defaults. The complaint is clear that it's challenges for the way that my clients manage the hotels, which impacted upon the performance of the hotels. The complaint cites right from Article 11 of the HMAs to support those allegations.
So what does 12.1C deal with in your perspective, from your perspective?
There are enumerated categories in 12, such as if my client failed to procure insurance, that would be an immediate event of default that they could then terminate if the insurance wasn't reinstated. But there's nothing in 12 that talks about performance-based disputes. And in fact, in 11, which details performance-based disputes, 11C says, and you also have the right to terminate under 12. But then when you look to 12C, which is the catch-all, it talks about other defaults. So our position is that when you try to read these two together, and we think the lower court erred in doing this, that the only conclusion is that performance-based disputes are dealt with under Section 11, and other defaults are dealt with under Section 12. And I think the real proof of that is in the consideration that's exchanged here, because as I started saying earlier, my clients received 2 years where they were supposed to have unfettered access and uninterfered access from ownership in managing these hotels. And the quid pro quo for that was that under the promissory note that was extended, that if after 2 years there was a performance-based termination that was properly instituted, properly noticed, and properly established, then my client would not receive a termination fee, and the promissory note would not be subject to reduction.
Would you agree that as part of the complaint, ALG, who was part of this whole transfer process, in a separate transaction agreement to which it was suing in this complaint, is not subject to the arbitration provision because there's no arbitration provision in the transaction agreement?
Oh, no, we disagree. We believe that the whole complaint is subject to Article 11.
I understand
And
that.
that under Article 11.
But ALG is suing under the transaction agreement for
No,
breaches.
so this gets to cause of action 5, and we think that the lower court improperly refused. First of all, the lower court didn't consider the arguments raised in cause of action 5. And we think that the effort to squeeze into this
relates
case.
to the transaction agreement. So how does the hotel management agreement provisions protect you in terms of count 5?
Sure. So the HMAs are very clear. There's a limitation of liability provision in Section 14.14, which says that only the contracting parties, in essence, only the parties to the HMA are going to be liable for the HMA, and not their affiliates, which is the critical point for this appeal. Cause of action 5 deals with Pyramid BMC, which is an affiliate of the entity managing the hotel. So what the respondents argue is that the obligation under the transaction agreement to manage the hotels was an assumed liability of Pyramid BMC, and therefore under the transaction agreement through this 2.03b, they can get to Pyramid BMC. But it's wrong, and the lower court didn't consider any of this, but it's wrong for the following reason, Your Honor. 2.03 and the assumed liabilities are only assumed liabilities that ALG had when it was the party to the hotel management agreement. And the hotel management agreement says that ALG, as an affiliate of the ALG entity that's managing under the HMA, is never going to be liable for anything that the affiliate does. So there can be no assumption of the liability that ALG itself didn't have and placed onto Pyramid BMC, and that's why cause of action 5 fails, because there's no independent way to get to Pyramid BMC through the HMA when ALG itself had no obligation under the HMA to manage the hotels.
You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. E. Tyraz of Prior Cashman LLP on behalf of the respondents, and may it please the court.
So what allegations do you make that are not performance-based allegations, which would fall under Article 11, under which they would have a 2-year period to perform?
So just, there's a few pieces there, and if I may, I'll take them in turn. In terms of the allegations of performance, the Article 11, all it looks at is two financial metrics: gross operating profit and revenue compared to the competitors of that hotel. Excuse me. It doesn't ask, did they perform sales and marketing, which they're required to do under Article 3? Did they supervise and train employees, which they're also required to do under Article 3? Did they comply with the express limits on spending, which is in 3.2C? Did they perform accounting services like in Article 7? It doesn't look at any of that. It's just, did they technically pass or technically fail? That's what Section 12.1C is for. It's for all the other covenants and obligations. And for instance, 12.1B that my friend gave as an example.
So what language would you point to in Article 12 which says what you've just said? Because your colleague says, well, it talks about insurance, licenses, permits. Where does Article 12 have those duties?
Sure. So the examples that you're giving are actually different portions of Article 12. For instance, the insurance piece, that's 12.1B. 12.1C, and this is a common clause in these types of agreements, is if they breach any of their other covenants and obligations, they have many obligations, like some of the ones I mentioned in sales and marketing, human resources, training, spending, all these things that they have to do. Article 11 doesn't absolve them of that because it doesn't look at it. And in fact, in Article 11 itself, the parties recognize that. So in 11.1C, the parties agreed that, let me just get the language in front of me. The parties agreed.
So under 12.1C, did you give them 30 days notice to cure?
Yes, we did, Your Honor. So in advance of filing this lawsuit, each of the hotel owners served 5-page detailed notices of default, and that's in the record, alleging some of the defaults that I just went through in sales and marketing and human resources and training and all these different things. We allege that those defaults went uncured, and pursuant to Section 12.1, after 30 days, my clients were entitled to exercise all of their rights and remedies, including filing the underlying lawsuit. And some of the examples I gave, it's all in the complaint. It's all the notices of default are part of the record. So, Your Honor.
But the central point of their brief is that all of the allegations that you make of non-performance do relate to performance-type matters which fall within Article 11. They're all dealing with these financial metrics which you allege they didn't live up to. And therefore, it's an Article 11 and not an Article 12.
Your Honor, so I think we look at it.
To some extent, you've answered my question about that already, but not completely.
If I may say one more thing about it, that perhaps will get you to my side, hopefully. The performance related to the financials, I would like to say the word performance doesn't appear in Article 11. That's just a term that's used in the industry. The financial issues that we're seeing, those are the consequence of the operational breaches. The hotel owners are not suing because they missed budget by however many million. They're suing because they didn't perform sales, they didn't perform marketing. There was massive turnover at key positions on property and above property. There wasn't appropriate corporate support. The financial documents were wildly inaccurate. It's operational breaches. They're not suing because they missed the budget. That's the consequence. And so if it was...
You're stating that therefore falls under 11.1?
That falls under 12.1C, and 11.1C makes clear that an event of default can exist alongside, irrespective of whether or not there's financial issues that may implicate the performance test. The court found below there's two avenues, and this is why this is important. If you agree with the position put up forward by the appellants, then that would mean that they can choose not to do sales and marketing, that they can choose not to hire employees, and they can choose not to train them, and they could walk into the hotel with Burger King outfits, and it doesn't matter because maybe they met their performance test.
Well,
but that's not.
I'm sorry, I didn't mean to cut you off, but that was raised below, and in a sense, if your friend's argument holds sway here, then it pretty much eliminates 12.1C.
That's exactly
There would be no
right.
reason for that clause.
And even further, not only does it eliminate 12.1C, it would eliminate their obligation to do sales and marketing and their obligation to do a training and to do accounting, because at that point, what is the consequence? If they don't have to do it, if we have to wait 2 years and just prove that these two financial metrics are met. And if I may just briefly, because I'm running out of time, I'd like to briefly talk about the fifth cause of action by ALG. There are three.
That's breach of the transaction agreement?
That's right. There's 3 contracts at issue here between 6 different parties, right? There's a plaintiff and defendant on one hotel management agreement, a plaintiff and defendant on another hotel management agreement, and then Aspen Lodging Group has its own breach of contract claim against Pyramid BMC, its own counterparty. In Section 2.03, the way this works is ALG sold Pyramid the right to manage 10 hotels around the country. In exchange, Aspen Lodging Group got the right to earn money on a promissory note in the future that depended on Pyramid BMC continuing to operate these 10 hotels. And so, if I just may finish this one point.
Please.
So they're financially invested in their continued performance. And so Section 2.03b says that Pyramid will assume the liabilities, which is defined as obligations, under the contributed contracts, which is the hotel management agreements, for these 10 hotels. It's a separate contract between separate parties. ALG is suing to pursue its own contractual rights and its own damages against its own counterparty. Neither of these parties are signatories to the hotel management agreements, and those are separate issues between separate parties, and I thank you for your time.
Thank you.
So I'll pick up on the last point. The problem is that ALG wasn't responsible for the management of the hotels under the HMAs. The individual entities are responsible for the management of the hotels under the HMAs, and 14.14 makes clear that nobody else is going to be responsible. So that liability didn't exist on ALG when it was in the position of Pyramid BMC, and therefore it's not an assumed liability under the transaction agreement. The other thing to keep in mind is that they're trying to
Well,
bring.
doesn't, it also states, however, that liabilities thereunder are required to be performed after the closing date and were incurred in the ordinary course of business.
Well, that speaks, Your Honor, to the fact that my client is now managing the hotels through its individual
Right.
subsidiaries created. But the provision is clear that the affiliates of those individual subsidiaries that are managing the hotels are never going to have liability.
Why would that not be what is it called, an assumed liability?
Because it's not a liability that ALG had when it was standing in the position that my client was in, because ALG was an affiliate of the entity that it created to manage the actual hotel. And the language is clear in that regard. 2 other things I wanted to touch on quickly. There's a separate action that this court is aware of that is wholly founded in the inability of the respondent to bring claims in this action for these other 7 hotels. And the record's very clear about that. And what they're trying to do through cause of action number 5 is what they cannot do, which is sue in this case for damages related to those 7 other hotels. It's a creative argument that they're making, but it's not substantiated by the actual transaction agreement because it's not a liability assumed, and it's not substantiated by the allegations they're making in the other related case that they were precluded from bringing in this action claims against those other 7 hotels by breaches of fiduciary duty between the members and the parties in that case. The other thing I wanted to touch on quickly is that there is a fundamental issue that the lower court overlooked about the interplay of insurance on the limitation of liability in 1414. 1414 is very clear that liability is limited between the entities to the HMA.
Well, that would be for their own assets, but not for the insurance.
This is the issue that I wanted to touch on. And what the lower court said is that and what they argued below is there may be a workaround that limitation of liability, which we disagree with because of insurance. And what's clear when you look at the HMAs is that we don't agree there is such a workaround. But if there is such a workaround, then the only insurance that's at play is the insurance applicable to the claims in the case, which are management liability claims. That insurance per the HMA is $1 million. So either way, you get back to this limitation of liability being $1 million. There is an excess and umbrella policy called for in the HMA, but it's very clear that that coverage is only excess of the automobile liability and the commercial general liability, not the management liability insurance.
Just humor me, may I ask just one final question? I don't believe this is so, but correct me if needed. Does this limitation of liability as to the 1 million for the one hotel, the 2 million for the others, is that limitation in the transaction agreement? I don't believe so.
No, that comes from the hotel management agreements.
Thank you both.
Thank you.
No. People v. Khan. Proceed.
Good afternoon, Your Honors. Sean Nuttall, OAD, for Mr. Khan. I'd like to start with the sentencing point. It's the most clear-cut and requires only limited relief in what we acknowledge is a very serious case. If I have time, I'll turn to the confrontation problem and also the sequestration error. A sentencing court must ensure that all the information it relies upon is reliable and accurate. Here, respondent concedes that the judge below could not verify the accuracy of the multi-level hearsay that it relied on regarding this allegation of prior conduct. That is the ballgame.
But I believe on this record, the court made clear that it wasn't relying on it.
No, Your Honor. It says that it acknowledges that the evidence is of less reliability than what it just went through at trial. But it says, I think it is of some relevance that the defendant sought to engage in the similar conduct on a previous occasion. I think it is certainly indicative that there was something going on here besides just this one incident. It's very clear that the judge is relying on this. And in fact, it's one of only two aggravating factors the court points to in imposing the sentence.
Well, I don't know that it's very clear that the judge relied upon this. But at the time the judge made that statement, what was counsel's response?
Counsel says, the prosecution says, look, we haven't been able to verify this. They're very candid about it. But there are these allegations of prior conduct. And defense counsel says, we don't know anything about these people. It is multi-level hearsay. The court agrees with that. It is very hard to enhance.
My question was, what was counsel's response? Did counsel say, Judge, we don't want you to consider this. You should not consider it, given the fact that it's double hearsay or what have you, it should not be considered?
Yes, Your Honor. Sorry, I was just trying to get there.
Really?
Yeah, it is very hard to enhance a penalty based on something that we know so little about. I am asking you not to do that in this particular case. That's sentencing page 15. And in regards to how much the judge relied on this, I'd like to point the court to the Supreme Court's decision in Townsend, which is quoted by the Second Department in Barnes. The reviewing court is not at liberty to assume that items given emphasis by the sentencing court did not influence the sentence. Rather, to require vacatur, it is sufficient that the court took that information into account in making its determination. There's no question that happened here. Maybe I could emphasize. Sorry, Your
based
Honor.
upon the record, based upon the testimony as to what occurred in this horrendous incident, can we really state that the reason that the court sentenced the defendant to 14 to life was in any way based upon these arguably unsubstantiated statements?
Well, Your Honor, to cut to the chase, the court doesn't have to. If you send this back down to Judge Convisor, he can make that determination himself and reimpose what he determines to be an appropriate sentence based on reliable information. But again, the Supreme Court, the Second Circuit, the Court of Appeals, the Second Department, the Appellate Division, including in egregious cases, murder cases, arson cases, when a court relies on unreliable evidence at sentencing, this court has not hesitated to send the case back
See,
down. for
my
a new
problem is you're
sentence.
trying to prove a negative. I don't the judge never said, I am considering this in my determination of sentencing. He never states that.
I'll just quote from the transcript.
I have the transcript here.
So on page 18, I want to go through a couple of things about this case and about my considerations in sentencing. The next paragraph is about this crime and that it is brutal. And then he goes on, I think it is of some relevance that the defendant sought to engage in similar conduct on a previous occasion. That is based on these hearsay allegations. I realize the reliability of those allegations is not the same as the reliability of the conviction he has here, proved at trial. But and of course, as defense counsel says, it is double hearsay. And the prosecutor has said we couldn't verify it.
And the court acknowledges that.
Yes, Your Honor, but it's not a balancing test. It's not, if it's a little reliable, I can rely on it a little. The law is clear. If the court cannot determine the reliability of the evidence, it cannot rely on it. That's the end of the story. Thank you.
Thank you.
May it please the court, Alexander Michaels on behalf of the people. To touch first on the preservation issue as to the sentencing discussion, I just want to make clear the defense's argument here was much more of a weight argument rather than an admissibility argument if we were in the trial context. The defense is absolutely saying, you shouldn't be persuaded by these accusations and these messages because they're not particularly reliable. The defense is not saying you are legally prohibited from considering these messages. The defense is coming nowhere near to saying.
So does defense counsel have to say that? Does he have to actually say when he says you shouldn't consider it, does he also have to say, and I object if you do?
It obviously depends on the particulars of the communication, but this court has held repeatedly that if there's any constitutional dimension to an objection or to an argument that's raised on appeal, and as there is here, there's
So he has to say the magic words, I object to your considering the
not necessarily those particular words, but he has to say that you're not allowed to consider those, those messages. They haven't been, their reliability has not been sufficiently established for you to consider those full stop. As Justice Weber was asking about what counsel said in response to the judge's comments that there's some relevance to these messages. Counsel said nothing at that point. That would have been.
He didn't say note my objection for the record?
No, he did not say anything along those lines. He did not say that there was any due process concern associated with considering these in any way. So again, it's a question of admissibility that he doesn't get to. He simply argues that these messages are not persuasive.
The court did go on to say at some point during sentencing that it took into account a variety of factors. How do we know that this was not one of the varieties of factors that the court took into consideration?
I mean, the court does acknowledge that there's some relevance here. So it's impossible to assume that there was no, that the court didn't consider it in any way. The court does say there's some relevance here. But what's crucial is that the court discounts that relevance significantly.
Your friend didn't get a chance to make these points, but I'll let you sort of respond in a way. With respect to the DNA evidence and the confrontation clause, essentially that issue is unpreserved, correct?
Absolutely, yes, Your Honor.
And with respect to the sequestration of the two sisters, the claim that they coached each other on their testimony, essentially, as I understand from the record, the victim said what she said about her experiences and the fact that she knows them to be, and the sister testified as to how she came to the rescue post-crime, so to speak, correct?
Right, Your Honor. There is very minimal overlap in terms of what the two sisters were testifying about.
Fair enough.
Okay, and to return to the question of the sentencing, the sentencing court did make clear that he was not accepting these allegations at face value. He said, as my friend has already quoted,
I think defense counsel's point with this argument to get to the bottom of it is that he's sort of saying, well, the judge is talking about it. He's not saying he's relying on it. But maybe if the judge didn't consider this, instead of giving the defendant 14 years, he would have given the defendant 13 years.
I understand that to be the defense's point, and my response would be that it was totally appropriate for him to rely on these messages in a very limited way. And this was not hashed out at the sentencing because the defense did not object, but it is hashed out in our brief. And the crucial thing here is that the defendant at trial, his position seemed to be that he was genuinely confused somehow as to whether the victim had implicitly consented to this awful conduct because she was a prostitute. And then in his pre-sentencing memorandum, defendant seems to be personally maintaining that position, because in his pre-sentencing memorandum, there's a suggestion he does not agree with the facts of the case, I think is exactly the way it was put there. So it was perfectly appropriate for the people to bring this to the court's attention, because at the very least, it responded to his ongoing suggestion that he was unaware that prostitutes might not consent to this kind of activity.
Isn't that part of his effort to try and get in certain statements he made through the sister witness in terms of his characterization of their activity?
Sure, it goes back to that, but in the sentencing context in particular, it's very relevant because it goes to his notice, right? He has noticed just by virtue of having received these messages, whether they're accurate, whether they're not accurate, the fact that he received these messages shows that he is on notice that prostitutes do not necessarily consent to all of this kind of sexual violence that he subjected this victim to. Because he is on notice of that, it is very much a relevant consideration for that limited purpose. And so that seems to be what the judge was getting at when he was saying, you know, it's indicative of something else going on here besides this particular case. And so that is what's perfectly acceptable for the judge to do, and it's a reason for this court not to reach the issue in the interest of justice, because, as I was explaining before, the issue is not properly preserved for appellate review.
Thank you.
Thank you.
I think the main problem with what respondent is arguing is that where it's sentencing at trial, there's no weight versus admissibility. There's just considering something for purposes of sentencing or not. So that takes care of the preservation point. There's, Judge, your question, there's no requirement to renew the objection after he's already said, do not enhance the sentence based on this information.
Does he say that? Do not, I didn't.
Yeah,
does he
sorry, let
say
me just
do
read
not
it one.
enhance?
I did not hear that.
Let me read it one more time. We have no idea whether these people, it's double hearsay, it's not my client's statement, it's double hearsay, are honorable, not honorable, or, chronic habitual liars. So it is hard to enhance a penalty based on something that we know so little about. It's easy to draw the most negative conclusions and assume the worst. I am asking you not to do that in this particular case.
Okay, so he asked not to do that. How do we know that he did it?
Well, then,
how do we know that he did not accede to the wishes of the defense and not do it?
Well, 2 points, Your Honor. To go back to what Townsend said, Supreme Court of the United States, the reviewing court is not at liberty to assume that items given emphasis by the sentencing court did not influence the sentence. It is sufficient that the court took the information into account, and that is precisely what the judge does on page 18 of the sentencing.
Also, I'm kind of losing you in the sense that
Yes.
the facts of this particular case are so overwhelming as far as their brutality, the sadism, the planning, the intentionality, the use of weapons. I don't see that the 14 years to life under these really, really extenuating circumstances is so unusual or excessive.
We're clearly not making an excessive sentence argument. We are making an argument that the process the judge below used to reach
But
the
I'm
sentence.
saying the same thing, just in a different way.
But
Which
that's-
is to say, given all of this could very well be a reasonable outcome.
Could very well be, and if this goes back down, the court could reimpose the same sentence. If I could just finish up. In Naranjo, the Court of Appeals vacated a sentence for 8 violent felony offenses, including 5 Rob 1s, because of a single allegation of prior misconduct that was not substantiated. In Barnes, that was a murder.
Was that a bench trial also like this?
That was a jury trial.
That was
I
a jury
believe.
trial, but we're talking about a bench trial.
But the court should still be able to consider that, and that's
The court
again,
meaning us?
If this goes back down, Your Honor, the people will again have the opportunity to try to prove the reliability of this information. Judge Convisor will again have full discretion to determine what the appropriate sentence is. And there is a chance that based on the conduct here, that he will say, you know what, 14 years is still the appropriate sentence.
He could even say more.
If it's not penalizing my client, that's right.
So you're asking us to vacate, remand for Judge Convisor to say, I did not consider the statements in sentencing the defendant to the 14 years to life.
I think it is clear that he did consider it, Your Honor. That's our position.
Giving him 14 years anyhow.
I'm sorry, say again, Your Honor.
Judge Convisor could very well say that I'm giving him 14 years anyhow.
He could, but that's for Judge Convisor. And I also want to just stress, no matter what, my client is getting life on the back end. The question here is really at what point the parole board should determine if he is ready for release.
Thank you. Thank you both.
Thank you very much.
373-381 Paz Associates, v. Moss. Yes, proceed.
Good afternoon. May it please the court.
I think you need to move the mic up a little bit so we can hear you.
Sure.
You represent Herman, the Herman firm?
Yes, I represent Walker G. Harmon.
Harmon, excuse me. So it wasn't you, I don't believe. It was someone from your office who submitted a request to submit a late reply. Late meaning yesterday afternoon, which I received it this morning, asking to reply when the case is on, as we can see now, for oral arguments. And so that application was denied. We don't accept late replies hours before the actual arguments because, believe it or not, we actually read the papers prior to an hour before the arguments. Go ahead.
I understand. Thank you. So I am here today appealing a decision by the Supreme Court, which granted summary judgment in favor of 373-381 PAS Associates, which I'll just call PAS, and denied our motions for summary judgment. This case is a commercial tenant case about...
Counsel, let's focus a little bit. For starters, your client alleges that the firm and he were ousted and locked out from the premises.
Yes.
Could you explain that in light of the fact that the accountant, Ms. Rosado, testified that a move out, it's not the right word, a move from the office was contemplated because the space was too large?
And the firm was winding down.
Sure. So to the first point, I believe that the accountant had averred that she was not technically an employee.
I can't hear you.
I believe that the accountant had averred that she was not technically an employee. That being said, her testimony was that she was let in to the building by a
security guard
and was not given her own free access into the space.
But if you move out and you leave a premises without paying rent, and usually that's called abandonment if you leave prior to the culmination of your lease. How is that an ouster or an eviction?
Well, a somewhat maybe frustrating or complicated issue is that Mr. Harmon had sought, or I should say the Harmon firm had sought the deposition of John Moss, which is he's, speaking for respondent Moss and Moss today. There were allegations, and Mr. Harmon had veered through declarations that the Moss firm had treated him as an adversary, had changed the locks, had not delivered any kind of a key.
But the change of locks occurred after the Harmon firm left the premises.
In February of 2020.
So this all, to your point, of February 2020, this all began right when COVID started, which was when everybody was forced to abandon their various premises for various city regulations and such. The crux of the timeline is COVID begins, everybody leaves their premises. The Moss firm has a disgruntled...
But I thought that Harmon had stated that they were winding down prior to COVID. Yes. That Harmon had made statements that he was winding down prior to COVID.
They had. That ended up not happening for quite a while. The Harmon firm is now closed, but I think that the Harmon firm persisted.
Apparently, Harmon told Ms. Shadow in February 2020, prior to the onset of COVID, that he intended to wind down the operations, the firm's operations, and vacate the premises.
Yes, Your Honor, but before that actually happened, before the firm was closed or before the firm had stopped taking clients or recused itself from any of its cases, the locks were changed in April.
The locks had changed on April 2nd, 2020 at Moss's request.
Mm-hmm.
But Rosado is given a key, isn't she?
No, Your Honor, she was never given a key. She was only granted very temporary access by a security guard.
But they didn't deny access to her, correct?
They did not deny access to
So
her.
does that constitute an eviction if they didn't deny access?
You can think about that and respond on rebuttal. Thank you.
Thank you.
I'm not as tall. Good afternoon, Your Honors. May it please the court. Joshua Kapelowitz, Fox Rothschild for plaintiff respondent, 373-381 PAS, the landlord. I believe that our papers are sufficient. I'm happy to answer any questions you may have.
Very quickly, would you agree that when you moved for a default judgment against Mr. Harmon individually, that you did so beyond the 12-month period, is really 18 months?
All right, not 12-year period.
I corrected myself.
I would agree that we moved either, depending on what time frame you're looking, either 6 months after the 1-year time frame or 1 month after the 1-year time frame, because if you recall, Your Honors, the case was brought, and then the Harmon firm, which appeared and was served at the same place as Mr. Harmon, then made a motion to dismiss. That took some time for the court to deny.
And speaking of that service at the Fifth Avenue place, they claim that wasn't his principal place of business, but the record says to the contrary, correct?
Correct, Your Honor. So then they submitted an answer. Our motion was 1 month after, 13 months after their answer to answer the first question, to answer the second question. Correct, Your Honor. And the 2 years worth of records that we submitted to the court show that Mr. Harmon represented, advertised.
Well, what happens if you move for a default more than 12 months after the default? What's the penalty for that?
Well, there is no penalty per se. It's that there's a burden on behalf of the movant landlord to show that they didn't abandon the claims, and you can show that a variety of ways through settlement
To
discussion.
avoid dismissal of your claim, but that provides the defendant with an opportunity to answer, doesn't it?
It does, Your Honor. And defendant here, Mr. Harmon, never answered, never made a motion to extend his time to answer. He did appear for depositions. He did appear for argument. He did appear to put in a motion in opposition to this. He did put in papers in opposition to the summary judgment, and he did put in affidavits on behalf of the Harmon firm's motion for summary judgment. So he participated in the case in every which way other than putting in an answer, and one can only assume that was strategically done.
Thank you.
Thanks, Your Honors.
Good afternoon, Your Honors. If it may please the court, John Moss for respondents Moss and John Moss. Similarly, I think the brief is quite comprehensive. There are no matters in the instant appeal. No relief is sought against either Moss and Moss or John Moss. So we request that the appeal be dismissed against us.
Thank you.
Thank you.
Okay. So to the first point about whether or not it was an eviction, I would argue that any time a tenant is not allowed, or a member of a tenant's, I don't know, employees or friends or what have you, is not allowed free and clear access to a space that they believe that they should have free and clear access to, I would argue that that's an eviction.
I recollect.
But if they were evicted, they wouldn't have let Ms. Rosado in
So
at all. They would have said, "I'm sorry, your law firm has been evicted."
So that's why I think we style it as a constructive eviction, because the locks were changed, and the locks were changed.
The locks were changed because Moss and Moss, co-tenant to the Harmon law firm, requested that the locks be changed, correct?
Correct. And then that is when
The reason for that was because somebody was leaving the firm?
yes, a lawyer, I think, by Mr. Deemer, I think his name was.
Does the record show that anybody requested a copy of the key after the locks were changed?
Whether Mr. Harmon requested a key?
Yes.
No, shortly after the locks were changed, Mr. Moss had sent Mr. Harmon an email saying that he was considered an adversary and that Moss and Moss firm would be considering action against Harmon. And at that point, it made it clear that Mr. Harmon was excluded from the space. And one thing that I want...
Was there a request made for a key?
Did Mr. Harmon make a request for a key?
Yes.
I don't believe that Mr. Harmon made a request to Mr. Moss for the key, no.
You appear for Mr. Harmon today. The most that you can hope to happen in your favor today as to Mr. Harmon is that he be given an opportunity to put in an answer. Is that correct?
Yes, yes and no. I think that yes to the idea that the default was never given any opportunity.
What other relief do you think he might be entitled to?
Well, for PAS to succeed on its claim, it has to show all elements of the breach of contract, including that it continues to perform. And Mr. Harmon has alleged that in being locked out, that PAS is not performing on the contract. And central to that is that we were never able to take...
Right now, he's in a default posture.
Mm-hmm.
So the best you can hope for is to be able to put in an answer and deal with these other issues you're raising.
Yes, and to your previous point about the 12 months, PAS never moved for the default in that period. And there was never an opportunity to answer. There was never an opportunity to cure. It was just granted, and then...
I'm confused. There are two aspects to the order below. One was the default judgment against Mr. Harmon individually, and then there was summary judgment against the Harmon firm, correct? Summary judgment means joinder of issue with a full and fair opportunity to deal with that issue in terms of the outstanding rent. So my point earlier was to your friend was when they attempted to get a default judgment against Mr. Harmon, they were late.
Yes.
Fair?
Yes, they were late.
Thank you all.
Thank you.
Last but not least, we have People v. Aaron Smith. Yes. Yes, you may proceed.
Good afternoon. Karen Brill with the Office of the Appellate Defender for Aaron Smith. Right before Mr. Smith's suppression hearing was about to commence, a judge turned the prosecution's open plea offer into an exploding ultimatum that required him to waive his case-dispositive suppression claims and plead guilty immediately or forever lose access to any negotiated...
When was that plea made to the defendant?
That's not stated on the record, but they said it. The prosecution's offer had been open for some time.
A month?
It was on the table for about a month, right?
At least, yes.
And so now we are at the stage of conducting the suppression hearing. And at that point in time, after 1 month now, the defendant is requesting an adjournment in order to consider that offer?
No, Your Honor. The defense counsel was happy to go forward with the suppression hearing that day, but the plan that had been put forth with the previous judge was to keep the offer open during that. Instead,
The case wasn't sent out for hearing and trial?
no, they had specifically worked out a plan with Justice Fabrizio that would go back to him with Justice Lorenzo, that it would go back to Justice Lorenzo after the suppression hearing with Justice Fabrizio. But what Justice Fabrizio said is, quote, "When I get a case, there are no offers that survive the witness testifying at hearing." That was a blanket refusal to consider any pleas negotiated after a suppression hearing.
Does a judge have a discretion to run the court according to his or her own rules?
Absolutely, but what a judge does not have a discretion to do is to reject a plea without consideration of the individual before them.
How did he reject the plea? If the defendant wanted to plead guilty, he could certainly plead guilty, could he not?
I'm referring to the prospectively rejecting a plea that was negotiated after the suppression hearing. This policy that there is no plea bargaining once the hearing begins. That's an impermissible policy.
Why is that an impermissible policy?
Because it's rejecting a plea based only on the fact that a suppression hearing had happened, not based on any of the individual circumstances related to...
So did you cite any cases that stand for the proposition you're now arguing?
Yes, Compton, which is a third department case, and Theodore, which is a second.
Now, those cases deal with coercion, right?
No, those are both about a court's impermissible policies that they are relying on instead of their individualized discretion. We also think this plea was coerced, but the abdication of
I
discretion
mean, the
is a
judge is
separate issue.
certainly permitted, is he not, to withdraw the plea offer if a suppression hearing starts?
No,
Is there anything wrong with the judge saying, look, this is the offer now. Once we start the suppression hearing, I'm no longer going to give you whatever number of years we're talking about?
Yes, there is something wrong with that because withdrawing, what that's doing is it's inserting into the prosecution's plea offer a suppression waiver condition.
He's not withdrawing the ability to plead guilty because obviously a defendant can always plead guilty, but he's saying this offer is off the table.
Yes.
Right now, if you take the plea, I'm agreeing to give you this number of years, but if we start the suppression hearing, I no longer feel bound by my agreement to accept that offer.
Right.
Where is what's incorrect about that?
The issue is that that's then a completely different plea offer because it involves a condition that you have to waive your suppression claims. And a court has no valid role requiring a defendant to waive their suppression claims. That's impermissibly adversarial.
Well, he's not asking him to waive his suppression claim. He's telling him this offer is no longer going to be available.
I'm sorry. Wasn't the judge, in responding to the colloquy and in urging the defendant to take this plea deal seriously, that he was at risk because of his historic record to potentially be subject to a felony C, which would have been a much higher sentence than the 5 years, which your client had been holding on to, the initial offer, for about a month, correct?
Yeah.
Is that coercive to tell a defendant, if we go forward, you're really at risk of really getting a much longer sentence given your violent past? Yeah. Whereas if you want to plead to the attempt here, maybe you should think about it right now. Do you hear what I'm trying to say?
It's not coercive to state someone's sentencing exposure. What's coercive here is that the judge created an exploding offer that did not previously
But let's
exist.
take a look at People v. White, right?
Yes.
So there, the Court of Appeal said, oh, you know what? There was no opportunity for the defendant and counsel to review this offer. So that's not exactly on the table here because there was that month's hiatus.
So I actually...
you can...
I'm sorry.
And the other part is that the defendant indicated that there was a possibility of perhaps a meeting at the DA's higher-ups to consider a better offer, but there was nothing scheduled.
Yeah, so I actually think White is an incredibly helpful case.
I'm sorry, incredibly what?
Helpful case to understand this, because what the Court of Appeal said in White is not that White didn't have time to consider the plea offer, but specifically that he didn't have time to apprehend the consequences of waiving the speedy trial claim. That's the same issue here. Mr. White did not have time to apprehend the consequences.
That's different because that was my point in terms of how long the offer had been on the table. The offer had been on the table for 1 month, so the defendant was well aware of what the offer was. Unlike in White, and also unlike in Compton, where in White, the defendant was required to make up his mind that same day. Same thing in Compton, the defendant was required to make up his mind and make a decision that same day. And the policy in Compton, the court's policy was told to the defendant that same day. Here, again, the defendant had 1 month to consider the plea. And now, at the stage where we're proceeding to the hearings, now the defendant is asking for an adjournment. So unlike White, the defendant had the opportunity, he had due time in order to apprehend the plea.
He had no time to apprehend the consequence of waiving his suppression rights.
He's not waiving, but he's not waiving his suppression rights. He's still, I don't understand, how is he waiving his right to proceed to the suppression hearing?
So the suppression hearing was scheduled for that day. What Justice Rubio says is before the hearing, so instead of the hearing, you have to take this plea.
No, that was not stated. It was if you want to plead guilty, you plead guilty now.
Before the hearing.
Okay, but that doesn't mean that therefore that you're giving up your right to proceed to the suppression hearing.
He states, I will see you all at 2:15 this afternoon. If your client wants to plead, He pleads. If he doesn't want to plead, then we move. Then we're done.
Exactly, which is before the suppression
He's
hearing.
being asked only to waive the plea offer if he wants the suppression
If he
hearing.
didn't take the plea, the hearing would continue at 2:15.
Right.
I agree, but I'm saying the plea that he took then meant that he had to waive his suppression hearing. That's a waiver of a case dispositive claim.
He has to wait. Well, you're not going to take a plea and then proceed to the suppression hearing. I'm not understanding.
Exactly, but the original plan for the day was to have the suppression hearing and keep the offer open during it. Justice,
Okay, we'll follow up on rebuttal. Thank you.
Good afternoon. May it please the court. I'm Vincent Revelisi for the Bronx District Attorney.
Counsel, I'm going to follow up on my colleague's question. I will see you all at 2:15 this afternoon. That would, I imagine, presuppose that this case was heard in the morning session and that there was a break, as in lunch?
Right.
So
And
that, in other words, a time was afforded?
yes, they were coming.
Can we assume that I will see you at 2:15 this afternoon is what it means to all of us?
It was to come back for the hearing, but then the defendant decided to take the plea offer. And I think he was out on bail, so he wasn't incarcerated, so there was opportunity to discuss with his counsel.
Is a one-day request for adjournment unreasonable?
Well, the
You're
court
right.
could have granted it.
The defendant is considering giving up his liberty for 5 years. A one-day request for an adjournment. Was that unreasonable?
Oh, it's not unreasonable. The judge could have granted it, but also had discretion not to grant it. And part of the
Could he have said, I'll hold the offer open for a day?
absolutely could have, and just we're arguing that it's not an abuse of discretion not to. And one of the things the judge asked when the defense asked for one day, the defense attorney says, I know it's in your discretion, judge, but could we have the day? And the judge said, well, has this offer been made before? And so he was clearly considering whether the offer was brand new or whether it had been offered. And it was offered a month before, and it was actually offered on more than one occasion. So there's plenty of time for the defendant to consider and discuss the offer with his attorney. So I don't think that that was the same as if the
I
offer
just
is
want to
made.
read to you what Judge Fabrizio said.
Yes.
So this is it. This is as low as it goes. And if he doesn't take it, then he faces a C violent and a lot of more time for as a predicate felon. And he can't even ever get this 5 again on this attempt offer. So this is it. This is it.
Yes.
Is that coercive?
Well, no, because it was truthful. I mean, it was truthful because the defendant had been offered a plea down from the top count, and he was offered less than what he was charged with, and he had been offered it for a month, and he had time to consider it, and so he had a choice to take it or not take it. And the judge wasn't saying he had to take it, and he
The
wasn't.
judge is saying if you don't take it, you're going to go down for the C felony and you're going to face a lot.
Well, the minimum is higher on the C felony, so
I
there's no
am
chance.
aware of that, counsel, but why did he even have to talk about the C felony?
Well, he was telling him the truth of what situation he was in, that if he didn't take the plea, he would
He
go
has
to
an
trial.
attorney. He has an attorney.
Right, that's correct. If he didn't take the plea, he would have to go to trial. And the judge is making that very clear, and I think the judge is allowed to make clear that he's not going to keep the offer open.
He could say, this is it, I'm not going to keep this offer open. That's it. He doesn't have to say, if you proceed, this is it, it's over for you. If it's a C felony, you're going to get more time.
But it wasn't a promise of retribution for taking the trial.
But does it sound like retribution?
Well, it sounds firm, and it sounds like it's truthful information that he's warning the defendant what's going to happen if he doesn't
Well,
take it.
we can't read the demeanor of Judge Fabrizio in this transcript, correct?
No, that's true. And
But the bottom line is whether or not this constituted some type of abuse of discretion
Exactly.
or was coerced.
exactly.
Did the people join in, did the people weigh in any way and say, oh, no, delay, 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 we want to go forward?
No, we didn't make any. In fact, when the defense started to characterize the people's position as to negotiations, the judge cut them off by saying, I'm not approving a lower offer for a predicate violent than the 5 years, which is already an offer down from the top count. So I'm not going to approve a better offer, so it doesn't make sense for the prosecutor to then answer whether they're considering a better offer. I don't have any indication that we were considering a better offer, and whether the allegations were true or not, I don't have that from the record, so I don't want to make any representations about what would be offered. We were asking the people are also asking that you find that the claim is unpreserved because the defendant didn't move to withdraw his plea and in fact said that they had a great relationship and they were looking forward to him never being back in court again.
Thank you.
Thank you.
Is that relevant at all, counsel, the fact that there was never a motion by the defendant to withdraw his plea? So he ultimately does plead, right?
Yes.
He pleads, what, after the suppression hearing?
No, there was no suppression hearing. He was
So he
forced to give it up.
he pleads guilty. He enters a plea of guilty, and he never moves to vacate the plea, right?
Yes.
Is that relevant?
Not in this case, because by the time that that happened, Justice Brizio had made his position abundantly clear that this was the only way this would go forward, is if Mr. Smith gave up the suppression hearing and pled
But he had the opportunity to move to vacate, stating and making the arguments that you're now making, right?
Yes.
And he did not do so.
Yes, but I think this case falls under the Court of Appeals reasoning in Finch that a litigant does not have to keep making the same protests once a judge has made his point clear.
But he didn't protest. Did he protest?
Counsel over and over again said to ask to keep negotiating after the suppression hearing to honor the original plan. Justice Fabrizio said over and over again, this is it, this is it. At that point, counsel confirmed that this was your final position, and then there were no further protests.
I'm sorry, counsel, wasn't there colloquy about his history and that he got a lenient sentence in an earlier gun case?
Yes.
And that was part of the consideration where the judge said, given your history and that whole back and forth and his counsel at the time saying we're looking for a D rather, or whatever kind of deals going on, the judge basically analyzed it all and
Yes,
said,
so
look,
thank you for...
you're sitting this for a month. This is the best I could do under these circumstances. It's 5 years. And while I won't necessarily read the colloquy the same way as my colleague did, but he was basically trying to tell your client, look, you're at risk if you go forward, correct?
So Your Honors can find that the court was never going to approve a better disposition, but the problem is that the very same disposition that was entered here did not originally require Mr. Smith to give up his suppression hearing. That was only a product.
Why did you have to move to withdraw the plea based upon, you're coming here now and saying, well, this plea can't stand because you forced us to give up our suppression hearing. Weren't you required in order to preserve this and make that motion that this plea needs to be withdrawn because I was forced to give up my suppression hearing?
I think in this context, no, because it was basically exhausted, but either way, there's still the...
I'm sorry, in this context, no, because...
No, because Justice Fabrizio had made his point clear and counsel was free to stop protesting.
It doesn't matter whether he made his point clear or he did not make his point clear. If you believe that he committed error, then you should move to vacate the plea.
So regardless of if you all find the coercion claim unpreserved, the adjournment claim is certainly preserved and it was an abuse of discretion. The abdication of discretion point is also preserved. That's the impermissible possibility. There are multiple ways to reach the same result. This plea should not stand, and so we ask that Your Honors vacate it and send it to a new judge.
Thank you.
Thank you.
Leave your phones off to leave the courtroom, please. Thank you very much. We appreciate it. That's all right. It happens. You're snapping a picture at the last minute. No, we don't want it.